All right, Madam Clerk, this is Judge Schally. I'm told that we have all necessary parties. I think that includes Mr. Mazon and his counsel, Mr. Dunmeyer, and hopefully a district attorney.
Yes, Judge.
Yes, sir.
Okay, then we can go on the record.
We're on record.
All right, we're now on the record at the Juneau Court. It's about 11:41 in the morning on the 27th of March. We're here for two cases, both are State of Alaska versus Mazon, Juneau 19225 and 19264 CR, respectively. The matters were set for bail hearing today at the defense request. Mr. Mazon is present by telephone from Lemon Creek, where he is in custody. Mr. Mazon, you're able to hear us all right?
Yes, sir.
Okay, very good. This is Judge Schally. Apologies, I'm a bit late. I was in the Sitka court by phone, and we had to take a break in the middle of the proceedings, and that put us off. In any event, Mr. Dunmeyer, defense counsel, is with us. And which of our district attorneys do we have present today?
Bailey Wolfstead, Your Honor.
Okay, Ms. Wolfstead is with us. Mr. Dunmeyer, what is your proposal or request?
So, Your Honor, I was trying to get Mr. Mazon out to a third party. Unfortunately, his sister is the only person locally, and she is disqualified by statute because of a pending misdemeanor case. So our request is to put an ankle monitor on him, to confine him to 24-hour house arrest at her place, with the only exception being for medical. And I know I think I might have put OR on my bail form, but I subsequently realized that due to the date of offense of these two cases, in both case numbers, the court can impose an unsecured performance bond or appearance bond, and I don't have any objection to that. So that in essence is what my request is, and I'm happy to go into more details as to why that's appropriate.
Ms. Wolfstead?
I absolutely oppose this bail request as strongly as I can, Your Honor. I understand that COVID-19 exists and is dramatically changing the scope of our community, but the court still has to make, and in the Carr decision that just came out, one of the things that they said was, this is absolutely a reason to get a new bail hearing, and I'm not opposing him having the hearing. I'm opposing his release. And the court still has to make individualized determinations based on the safety of the community, as well as all of the other factors that the court looks at. So let's start with Mr. Mazon's history. Some larcenies in 2013, a felony theft in 2014, a resisting arrest, a burglary in 2016, a larceny in 2015, and then an escape from a correctional facility in 2016, a felony escape. He was on parole, on a no-bail parole warrant for that felony escape when he racked up his first failure to stop for running from Officer Vaughn. A couple months later, Officer Schreiber spots him in the at around Safeway or Fred Meyer's. Safeway, that he drives to Fred Meyer's. Schreiber was off duty. He had called JPD to let them know that he had located Mr. Mazon. Officer Vaughn shows up on duty, tries to arrest Mr. Mazon, at which point Mr. Mazon throws his car into reverse, dragging Officer Vaughn. And I would say that if the court is considering releasing Mr. Mazon on this request, I would request that we set this over for Tuesday. I'm not allowed to physically be in a courtroom today. Today is my last day of not being allowed to do that because of my recent travels, so that I can show the court the body cam and dash cam videos that the grand jury saw in indicting Mr. Mazon, in which you can see from Officer Vaughn's perspective as he is being drugged underneath Mr. Mazon's car, begging him, please stop, you're going to kill me. And he doesn't. The only thing that stopped him was a snowbank that he crashed into. He then continued to jump out of the other side of the car and run. The only reason this was not worse for Officer Vaughn is Officer Schreiber was running alongside the car, physically holding Officer Vaughn up as much as he could so that he wouldn't get stuck under the wheel. Given the felony escape and those two failure to stops, including one which involved almost severely injuring or killing a police officer, Mr. Mazon is the last person who would really be eligible or appropriate for release here. They're just, I mean, an ankle monitor is not going to do anything because an ankle monitor is going to be cut off fairly quickly by Mr. Mazon. Given his significant history, given his penchant for running, and given his absolute disregard for the health and safety of others while he does so, he is not appropriate for release. And again, if the court is considering granting this, I would request the court allow me to play you the video so that you can see how serious this was and how severe Mr. Mazon's disregard of the safety of anyone in our community, particularly our police officers.
Very good. Mr. Dunmeyer, further comments?
Yes, Judge. So my client has 7 prior convictions. There is a resisting arrest, it's a misdemeanor. Beyond that, none of them appear to be any kind of violent crime. There's 3 larcenies, there's a burglary, and there's an escape too. In the case at hand, the more serious one, the assault one, my client was sitting in an idling car at Fred Meyer. It appears that he had finished shopping and was maybe texting on his phone or doing something before he left. Officer Vaughn came up and immediately did not park behind him, did not turn on his emergency lights, did not say, "I'm a police officer." He parked off to the side, out of my client's sight, ran up kind of pretty quickly up to the front door and tried to pull it open and yank my client out again in a car that was already idling. There's an automatic transmission, and the car very quickly reversed. It went forward. The whole thing took about 4 to 6 seconds. I understand that this was indicted on assault 1, and we're going to have to deal with that at trial. But I can tell the court that I think Officer Vaughn, while he did go to the hospital, had no injuries from this beyond like superficial scratches. And what I can also tell the court that was captured on body cam footage is that that same officer, just a few days prior, had seen my client and a woman walking down the street, and he stopped him in the street, had about a 10 to 15 minute conversation. My client was very cordial. He complied with the investigation. He wasn't aggressive at all. He answered all his questions. He stayed there when he didn't have to. And even at the end of the conversation, he tried to shake Officer Vaughn's hand, and Officer Vaughn refused. So my client doesn't appear to have a problem with law enforcement. This is just a situation where we will certainly argue at trial that Officer Vaughn created the risk by the way that he approached my client's car. And the reality is that we are in a whole new world, and this virus is barreling down at us. The best evidence that I have that I can see in documented sources that 20% of the people who contract it require hospitalization. And the sad reality is that the DOC complex or institutions, both in Alaska and in every other state, are going to be a petri dish for the transmission of this disease. Iran has released tens of thousands of prisoners to try to prevent this, and we need to do the right thing and reduce the jail population by as much as possible, not just for my client's benefit, but for the benefit of the entire community, because every single person who gets sick and needs to be hospitalized is one less bed that's available for someone else. And the conditions in DOC are not going to be confined to DOC. Corrections officers are going to take it home. People who get processed in or processed out in a day or two are going to take it home. People who get released from their sentences are going to take it home. And we need to do what we can to protect this community, and putting him on 24-hour house arrest will do that. So that's my request. And once again, even though I didn't put it in writing, I subsequently realized that the court can impose an unsecured performance bond. I think that would be appropriate in this case.
Your Honor, can I respond to the new argument about Corona?
Go ahead.
So actually, I actually saw an email that was sent out by the federal public defense bar to its contract attorneys, and because I want to point out that DOC has actually been doing incredible work in figuring out ways to prevent the spread of corona and the entrance into LCCC and other agency or other jails across the state. They've got protocols that they're following. The reality is, I am sure there are people who get sick. There are people in and out of jail who are going to get sick. There are people everywhere that are going to need hospitalization because this is a pandemic. What I will also note, though, however, is actually in that email, LCCC in particular was praised by the federal public defender as being one of the better locations, one of the places that they really don't have to worry about as much because of what they're doing and because of the superintendent and staff there. So I would say that as far as we go on that, absolutely we should be looking at who can be released. And I think the court knows that there are many cases that the state has come in over the past weeks and said, you know, I wouldn't normally agree to let this person out under these circumstances. I will, given the current state of the world. However, that's not a carte blanche for every defendant, and Mr. Mazon is not the right defendant. And again, because of the danger that he poses, and I'll note that Mr. Mazon had not gone in shopping at all because Officer Shriver had followed him from the parking lot of Safeway to the parking lot of Fred Meyer's. Never went in. He was sitting there. Officer Vaughn announced himself as a police officer. Mr. Mazon looked up, talked to him, dropped the clutch. Mr. Mazon reached over, you can see this on the video, dropped the clutch and geared it into reverse to run from Officer Vaughn. Certainly that'll be an issue at trial. And again, if the court is considering agreeing with this release, I would ask that we continue this so that I can play those videos for the court, or if there's some other way I can send them to the court now so the court can review what Mr. Mazon did.
Last word to Mr. Dunmeyer, if you wish to have it.
Yes, Judge. This was an automatic transmission car. There was no clutch. I don't understand where that accusation comes from. I am also on a listserv in which I receive at this point daily emails from Ms. McGrady, who is the head of the Office of the Public Defender, and we're sending out resources, sending out different trial court orders, and trying to figure out the best way to approach this. I haven't seen anything from her praising LCCC. What I can tell the court is I've heard from other clients that they ran out of bleach in that institution, that there is a DOC guideline that prisoners are not allowed to have hand sanitizer. And the reality is that with over 230 people in there, just inmates, not to mention guards and other staff, there's no way to practice social distancing, and I think the court knows that. The Court of Appeals addressed that in Carr. And, the reality is that there's just a tsunami headed toward us right now, and we need to do everything that we can to protect the community, and putting him on house arrest accomplishes that.
All right. Thank you, counsel, both. Pardon me. I agree that COVID-19, the coronavirus pandemic, is absolutely a strong consideration for this and any and all courts at this time. I've read the Carr decision, K-A-R-R, and moreover, I had already considered COVID-19 coronavirus and bail arguments prior to Carr coming out. So I agree. It should be, and of course under Carr, it must be taken into account. It is. I can't speak to what may be in an email from the federal public defender or not, but I highly doubt that as an officer of the court, that the district attorney would be stating something, making something up out of whole cloth. And I'm not suggesting that Mr. Dunmeyer was suggesting that Ms. Wolfstead was doing that, but you know, I personally have received probably about 150 emails about this COVID thing, actually more than that. I've got 150 that I've saved, and I've probably saved about 1/10 of the ones I've received, maybe 20%, just within the court system, the state court system. So there's a lot of darn emails. It is certainly possible that that one didn't make it to Mr. Dunmeyer, or he hasn't read it. But in any event, I basically, as an officer of the court, would trust the assertion about what's in that email. In any event, sure, I get it. There are problems with gatherings of persons, whether that's in a correctional institution or anywhere else. That's why, you know, Major League Baseball and all sorts of entities that have large gatherings of people have canceled their seasons or put them off, or, you know, whatever. So, you know, I get that. I also, though, have to continue to follow the law in a broad general sense when examining bail and conditions of release for any individual defendant, including appearance, including performance, public safety issues. Those remain very much on the table. I understand it seems to be fairly hotly disputed about exactly what may have occurred, or what is alleged to have occurred here. And yes, that'll all be ironed out when and if we do a trial in these matters. The charges are at a pretty high level. They are serious charges. Mr. Mazon has a fairly significant criminal history, at least one count of which, one conviction, the conviction for resisting arrest, would be in a similar vein. It does sound like there are some strong appearance concerns as well, given the information provided about the parole warrant and whatnot, and fleeing or attempting to flee. So I have appearance concerns, and I have performance concerns, public safety concerns. I guess I will mention one other thing, and I think that the lawyers, that is Mr. Dunmeyer and Ms. Wolfstead, may have anticipated that this was going to happen, depending on how much discussions they've had. But the court system, among the plethora of orders that have come from our state Supreme Court, our Chief Justice, and the presiding judges on a statewide basis, have addressed all sorts of things relating to this COVID-19. And about 3 minutes ago, I received the email that I was anticipating receiving this morning, which is the new statewide presiding judge's bail schedule based on the COVID-19 pandemic. It is effective today, and it temporarily, for the duration of this pandemic emergency, replaces the prior statewide bail schedule, the most recent iteration of which I believe was from early 2020, perhaps. In any event, this one's now in effect, and among other things, it's very lengthy, as these things tend to be. But one of the things that it does is, of course, it doesn't apply to felonies, but it still matters in this case. Almost all misdemeanors are now subject to OR. That's true of folks who are currently incarcerated on such matters, as well as new arrests. It basically converts bail down to OR. In many types of misdemeanors, certain types are exempt, domestic violence, that kind of thing. Also, all existing bench and arrest warrants that are out there, and in this community, Juneau, that would be probably hundreds, for persons charged with an offense that under this new bail schedule would be ORable, those bail and bench and arrest warrants are converted to OR. What this is, of course, designed to do is relieve the pressure and lessen, that is, the number of folks who are incarcerated at Lemon Creek and, frankly, any jail facility in this state. And I think it will have that effect. I think to a degree that although it does not empty the jail by any stretch, does go some way towards thinning the population there, literally and figuratively. And I think to some degree that goes a good distance towards addressing the concerns that Mr. Dunmeyer has. Again, I understand that it does not fully do that. Nonetheless, it is a factor that I think the court can, and which I am, considering as part of this overall bail proposal, because I think it frankly contributes something to this discussion. In any event, given all of the factors that have been discussed today at some length, I do not agree that this bail proposal for this individual with these particular charges and the particular criminal history that he has warrant granting this proposal. So I'm not granting this proposal. So the bail proposal is denied. Bail remains as previously set in these matters. Prior court date, whatever it now may be, I've lost track and I don't have the file here in front of me, remains whatever it was most recently previously announced to be. I think that would probably be for a trial date now in May, and this is probably on for a status hearing with me on April 15th. I think that's where most of my current pending felonies that weren't already put out further down the calendar have ended up. That date is subject to change as well, depending on the nature, scope, depth, degree, whatever of this pandemic emergency. But I'm not changing the future court date, whatever it is. So that's the court's ruling. At this point, I would ask Madam Clerk to just note on the TO with both case numbers that bail and conditions remain as previously set. Future court date remains as previously set, and she can note on there that this was ordered on the record. With that, we're off the record. I'm hanging up.
The chairperson has disconnected. The conference will now end.